Welcome to this explainer. When you really stop and think about the sheer power of the state, it's kind of staggering. The power to detain someone, to put them on trial, to literally strip away their fundamental liberty. It's hands down the heaviest burden any democracy carries. Today, we're taking a structured, chronological journey right into the very heart of India's criminal justice system. We're going to unpack the whole shebang, the massive framework of the Criminal Procedure Code, those landmark Supreme Court rulings that guard your constitutional rights, and that incredibly delicate balancing act between punishing the guilty and protecting the innocent. Make no mistake, the stakes we're talking about here are life and personal liberty. Let's get into it.
Okay, so here is our roadmap for today. We're going to navigate through 5 distinct stages. 1. Police, FIRs, and arrest. 2. Search, seizure, and bail. 3. Trial procedures and speedy trials. 4. Judgments, appeals, and compensation. And 5. Probation and juvenile justice.
All right, let's dive into this with Stage 1, police, FIRs, and arrest.
So we start at ground zero. This is where the theory of law crashes into the harsh reality of the streets. The law actually strictly categorizes crimes into 2 distinct buckets. On one side, we have cognizable offenses. Think of your serious crimes: murder, rape, kidnapping. For these, the police hold absolute, immediate power. They can launch an investigation, and they can arrest you right then and there without a warrant. But on the flip side, we have non-cognizable offenses. These are the less severe ones, things like defamation or simple hurt. In these cases, police power is legally put in check. They can't just arrest you. Actually, scratch that. They can't even start an investigation without getting a magistrate's warrant first.
Now put yourself in the shoes of a victim for a second. You walk into a police station to report a serious, cognizable crime. Can the officer behind the desk simply look at you and refuse to register your first information report, your FIR, just because they say they want to conduct a preliminary inquiry first? Well, this exact scenario sparked one of the absolute biggest constitutional conflicts in Indian legal history. And here is the climactic answer from the landmark 2014 Constitution Bench case, Lalita Kumari versus Government of UP. Notice the operative word here, mandatory. The Supreme Court boldly laid it down that under Section 154, if the information discloses a cognizable offense, the police have absolutely zero discretion. None. They must register the FIR. Preliminary inquiries, strictly banned, save for a very few highly specific exceptions like matrimonial disputes or medical negligence. So if an officer refuses to register it, they're actually the ones committing an offense. It's a real game changer.
But what happens when the police do arrest someone? We have to talk about the dark reality of custodial violence. In the absolutely pivotal case of D.K. Basu versus State of West Bengal, the Supreme Court forged an ironclad shield under Article 21 to protect everyday citizens. The rules are strict. Officers must wear clear identification badges, they have to prepare an arrest memo, and it has to be signed by a witness. The arrested person's family must be notified within 12 hours. Plus, the accused gets a right to medical exams every 48 hours and the right to consult a lawyer. Listen, this isn't just bureaucratic paperwork. This is literally the bedrock of human rights during an arrest.
Let's move on to the Arnesh Kumar case and see how this builds up our protection against arbitrary state action. See, previously, in matrimonial disputes like Section 498 cruelty cases, routine arrests were just destroying lives left and right. The Supreme Court finally slammed the brakes on this practice. They ruled that for any offense punishable by up to 7 years in prison, routine automatic arrests are completely banned. The police can't just lock you up on a whim. They must first issue a Section 41A notice formally asking you to appear. And if they do arrest you, they have to justify in writing exactly why it is absolutely necessary. It's a massive step in drastically curtailing police overreach.
Which brings us to Stage 2, search, seizure, and bail.
Okay, once an arrest is made, the tension really reaches a boiling point. The law instantly sets a ticking clock on the mighty state. Within 24 hours of being arrested, you must be produced before a magistrate. Period. No exceptions. From that exact moment, the police have a strict, hard deadline to finish their investigation and file a charge sheet. 60 days for lesser crimes and 90 days for serious offenses. Now here's the kicker. If the police fail to file that charge sheet before the clock strikes 0, the accused is granted what we call default bail. It becomes an absolute, indefeasible right. Basically, the state's own delay literally buys the accused their freedom.
So the crucial point is captured perfectly in the Sanjay Chandra versus CBI judgment. The Supreme Court was dealing with these massive economic offenses, but they delivered a super powerful universal conclusion. Bail is the rule, jail is the exception. The court stressed that keeping an unconvicted person in prolonged pretrial detention is a gross violation of Article 21. Merely because a charge is serious doesn't mean a person's liberty can just be sacrificed while they wait around for a trial to start.
Let's transition over to Stage 3, trial procedures and speedy trials.
All right, the investigation is over, and we are stepping into the resolute arena of the courtroom. But before a trial even kicks off, you have this absolute protection against double jeopardy, which is enshrined right in Article 20 of the Constitution. We use two historical legal terms here: autrefois acquit, meaning you've already been acquitted, and autrefois convict, meaning already convicted. Simply put, if you have been tried for a specific crime based on specific facts, the state can never, ever drag you through the fire for that exact same offense again. It is an impenetrable bar against endless prosecution.
But what if the trial just never seems to happen? Back in 1979, the horrific facts of the Husanara Khatun case completely shocked the nation. We had under-trials in Bihar jails who had literally been rotting in prison for years, some of them for longer periods than the maximum sentence they would have gotten if they'd actually been convicted. The Supreme Court stepped in with massive force here, officially declaring that the right to a speedy trial is a fundamental right under Article 21. This single ruling revolutionized the justice system, directly leading to the mass release of thousands of forgotten prisoners.
And this brilliantly illustrates the formal machinery of a session court trial when it finally does happen. It goes in steps. First, you have the formal framing of charge. This is where they tell the accused exactly what they're facing. Then comes the heavy lifting, the prosecution evidence. Now, if there's an actual case to answer after that, we move to the examination of the accused, giving them a direct chance to explain their side. Next up is the defense evidence, and finally, the ultimate judgment. It's a highly methodical shifting of the burden of proof, perfectly designed to uncover the truth.
Moving on to Stage 4, judgments, appeals, and compensation.
So the gavel has fallen. But sometimes we don't actually need a full-blown trial. The system smartly allows for compoundable offenses. These are lesser crimes that can be entirely settled out of court. And for offenses carrying up to 7 years, we have plea bargaining. This is a fascinating mechanism where an accused voluntarily pleads guilty in exchange for a mutually satisfactory disposition. This often leads to a drastically reduced sentence, sometimes like 1/4 of the minimum punishment. It's a win-win. It clears up the heavily clogged court dockets and provides swift closure for everyone involved.
Yet, in all this intense talk about the state and the accused, we really have to ask a hard question. When a conviction is handed down and the criminal is sent away, what happens to the victim? I mean, the person whose life was physically, emotionally, or financially shattered by the crime. For the longest time, historically, they were just left with nothing.
Well, that exact injustice was confronted head-on in the monumental case of Ankush Shivaji Gaikwad versus State of Maharashtra. The Supreme Court laid down a rigid, completely non-negotiable rule. Courts must mandatorily consider victim compensation under Section 357 of the Criminal Procedure Code when passing a sentence. And if a judge decides not to award compensation, they literally have to record specific written reasons explaining why. This was just a massive paradigm shift in Indian jurisprudence, finally moving the dial toward true restorative justice.
Finally, we arrive at Stage 5, probation and juvenile justice.
Down in this specialized branch, the rigid focus on pure, punitive vengeance is stripped away, and it's replaced by a focus on reformation. Consider the Probation of Offenders Act. The logic here is just brilliant and absolutely necessary. It allows for the conditional release of a young or first-time offender on a bond of good conduct. Why? Well, because throwing a first-time young offender into a brutal prison environment often doesn't reform them at all. It just turns them into hardened professional criminals. Probation legally protects them from going down that dark path, demanding good behavior instead of serving hard jail time.
And under the Juvenile Justice Act of 2015, we strictly contrast two vital categories of children. On the left, we have a child in conflict with law, or CCL. This is a child who has committed an offense. They are completely shielded from regular courts and instead handled by a specialized juvenile justice board, which focuses on inquiry rather than a formal trial. On the right, we have a child in need of care and protection, or CNCP. These are runaway, abused, or orphaned children, and they're handled by the Child Welfare Committee to ensure their safety and placement. It's crucial to understand that these administrative paths are totally separate.
Now, what's really interesting about this is seeing how intense public outrage actually shapes the law.
Following the horrific 2012 Delhi gang rape, the law was massively amended. For heinous offenses committed by 16 to 18-year-olds, the rules completely changed. First, a preliminary assessment is done by the Juvenile Justice Board. If they find the juvenile had the mental and physical capacity to truly understand their crime, the case gets transferred to a children's court. There, they can actually be tried as an adult, though it's important to note the death penalty and life without parole are still strictly off the table.
But think about this. How do we determine age in a system that is often plagued by huge delays? The Constitution Bench in Pratap Singh versus State of Jharkhand settled this incredibly forcefully. Notice the key distinction here. The date of the commission of the offense is what determines your protections. So if you committed a crime when you were 15, but the system takes 10 whole years to bring you to trial, you don't magically lose your juvenile protections just because you're 25 now. The date of the offense locks in your legal status forever.
So we've tracked the entire journey of justice today. We went from the mandatory filing of FIRs, to the shielding against arbitrary arrests, the right to default bail, all the way to intricate trials and juvenile protections. But I want to leave you with the gritty reality to ponder right now. With all these constitutional safeguards in place, and all these sweeping landmark rulings, is our justice system truly restoring society out there on the streets? Or are we merely managing the endless paperwork of crime? Really think about that. I hope this explainer brought you some real clarity today. Keep questioning, keep learning, and I'll catch you on the next one.